social development. The second was a pre-sentencing report prepared by Miss Jessie Thompson, a social worker in private practice, who sought to provide insight into Mr. Shoba's family life and circumstances. The third was the standard SAP 69 certificate, which confirms that Mr. Shoba has no previous convictions. The state cross-examined Miss Thompson. It asserted that a number of statements Miss Thompson made about Mr. Shoba's post-conviction use of a psychologist were unreliable, because they could only have come from Mr. Shoba himself. Mr. Muhammad asked me to attach little or no weight to those statements for that reason. I do not think it is necessary, however, for me to assess the weight to be accorded to what Mr. Shoba says about his sessions with his psychologist. Miss Thompson's report placed no reliance on those utterances, save to point out that the trauma of being tried and convicted of an offence of this nature is itself a form of retribution. While that is obviously true, that is not the sort of retribution a court weighs when it passes sentence. Criminal trials, while obviously deeply affecting for all involved, including an accused person, are the mechanism we have chosen to determine culpability and the legal consequences of that culpability, if any is found. Save where there has been pre-conviction imprisonment, the vicissitudes of the criminal process will rarely be relevant to the sentence to be imposed, unless, of course, they are particularly unusual or exceptionally distressing, whether to the offender, to the victim, or to society at large. In this case, there are no such exceptional features, and the shock and trauma Mr. Shoba apparently experienced on conviction do not in themselves bear on the sentence to be imposed. This is especially so because, in my judgment convicting Mr. Shoba, I found that Miss Pule's murder was premeditated. Section 51(1) of the Criminal Law Amendment Act 105 of 1997 requires me, on reaching that conclusion, to sentence Mr. Shoba to life imprisonment, unless there are substantial and compelling circumstances that justify a lesser sentence. Mr. Makabila did not suggest, and I would have some difficulty in concluding, that the obvious stress involved in being convicted of the offence could amount, in this case, to such a circumstance. I now turn to consider the other circumstances placed before me in mitigation and aggravation of sentence, before assessing whether they are, individually or in any combination, substantial and compelling. Mr. Shoba is 33 years old. He was born and brought up in a loving and supportive environment. He was well educated and otherwise well provided for. He took some time to decide on a career, but after 2 years of a law degree and some basic computing courses, he eventually alighted on a career as a financial analyst on the Johannesburg Stock Exchange. Here, by all accounts, he was in his element. He found the pressures of the job invigorating, and I have no reason to believe that he was anything other than very good at it. In argument before me, Mr. Makabila emphasized Mr. Shoba's productive career, his strong family background, and his previous good character. He referred to what he submitted was the Jekyll and Hyde feature of this case, that Mr. Shoba displayed, in his character and previous conduct, no indication that he could commit the offence of which I have convicted him. I accept all of this. The apparent asymmetry between Mr. Shoba's previous good character and Miss Pule's murder is one of the very many troubling features of this case. The fact remains, however, that the evidence placed before me points overwhelmingly to the conclusion that Mr. Shoba did arrange and participate in Miss Pule's murder. previous good character does not operate as a liability shield or a mitigating factor, where, as in this case, the facts so plainly inculpate Mr. Shoba in a very serious offence. It is to the nature of that offence that I now turn. Tshegofatso Pule was, by all accounts, a young woman of style and vivacity. The victim impact statement placed before me suggests that she was her family's emotional centre of gravity. The force of her personality, her optimism, her kindness, her empathy, and her generosity leap out from the way in which her family describe her. Her loss has been incalculable. The manner of her death, the intense media interest that has followed her murder, and the sheer yawning absence left in her stead have devastated all who knew and loved her. It is not necessary for me to set out, in any detail, the psychological consequences and emotional pain her family have suffered. Suffice it to say that those consequences have been particularly severe. Each of Miss Pule's close relatives suffers real and continuing anguish as a result of her death. While time may ease the pain, it is clear to me that each of Miss Pule's close relatives will live under a real burden of loss for most, if not all, of their remaining lives. I have said that Miss Pule was vivacious, but it is equally clear to me from the evidence led at trial that she was also a vulnerable young woman looking for care and attention, a meaningful connection that she thought a relationship with Mr. Shoba might be able to give her. Her vulnerability was not just emotional, it was material as well. As her pregnancy progressed, she relied in no small measure on the financial support that Mr. Shoba provided. That reliance only deepened as her pregnancy with Mr. Shoba's daughter went on. This vulnerability both animated Mr. Shoba's decision to kill Miss Pule and formed a critical part of his design to do so. It is clear from the evidence that Mr. Shoba wanted to be rid of Miss Pule and the baby. They were an inconvenience to him and to his hopes of pursuing a relationship with someone else. But it was also Miss Pule's dependence on Mr. Shoba for money to buy baby clothes and to transport her to and from his home that gave Mr. Shoba the opportunity to arrange her abduction and murder. That is probably the most aggravating feature of this case. That Miss Pule was pregnant when she was killed is also plainly very aggravating, as is the degree of planning and persistence that Mr. Shoba demonstrated in bringing about Miss Pule's death. He contracted another to carry out the killing. He made 2 attempts to do so, first by trying to arrange her abduction at the Ormond McDonald's outlet, and then by delivering Miss Pule into her killer's hands outside his home at the Westlake complex. It is clear from all of this that Mr. Shoba was the prime mover in bringing about Miss Pule's death. Although Muzikaise Malapane inflicted the fatal wounds, the evidence is that he would not have killed Miss Pule unless Mr. Shoba contracted him to do so and helped him to carry out that contract. It has gone unchallenged throughout these proceedings that Mr. Malapane had no other connection with Miss Pule other than through Mr. Shoba, and no detectable motive to kill Miss Pule other than to carry out his contract with Mr. Shoba. It is clear, therefore, that this offence is one of the worst kind. A contract killing that exploited the dependency of a vulnerable young woman and that resulted in the death of a baby very soon to be born. It is these features of the case that have excited an unusual degree of public interest. But even without that interest, the needs of society would have pointed towards a very lengthy custodial sentence. I accept that the exploitation of a vulnerability inherent in this offence is closely connected to the general and unacceptable level of violence against women and children in our society, which the criminal justice system must play its part in addressing. I have taken that into account when considering the appropriate sentence. While accepting all of these aggravating features of the case, Mr. Makabela urged me to find that a departure from the statutory penalty of life imprisonment was justified. He advanced the contention that Mr. Shoba should not receive the statutory penalty because it was not imposed on his accomplice, Mr. Malapane. Mr. Malapane was sentenced to 20 years in prison. I was asked to find that the need for parity in sentencing between Mr. Malapane and Mr. Shoba is in itself substantial and compelling enough to depart from the prescribed life sentence. Other things being equal, this would have been a strong argument. It is a basic principle of sentencing that one should strive to punish co-perpetrators equally unless there are some circumstances justifying differential treatment. But in this case, other things are plainly not equal. Mr. Malapane confessed to his part in Miss Pule's death. Despite initially and unwisely seeking to mislead the police about the manner of Miss Pule's death, in the end, he provided information and evidence which assisted the police in apprehending Mr. Shoba and in successfully prosecuting him. In my judgment convicting Mr. Shoba, I pointed out that, despite attacks on Mr. Malapane's credibility, the core of that evidence was left substantially unchallenged at Mr. Shoba's trial. These are plainly circumstances that Mokgotlenje must have thought justified a more lenient sentence than Mr. Malapane could otherwise have expected. There is no comparable factor that would justify a departure from the prescribed statutory penalty in Mr. Shoba's case. Now I accept that, as Mr. Makabela submitted, I should not punish Mr. Shoba merely for pleading not guilty and maintaining his innocence. But that does not mean that Mr. Shoba is entitled to the leniency that was extended to Mr. Malapane. The default legal position in respect of both men is that they would both have faced life imprisonment unless such a sentence would be disproportionate. To say that Mr. Malapane's cooperation with the police rendered a life sentence in his case disproportionate is not the same as saying that Mr. Shoba is being punished for not cooperating with the police. I am also persuaded that Mr. Shoba's role as the prime mover in the planning and commissioning of the offence distinguishes his situation from that of Mr. Malapane. But for Mr. Shoba, Miss Pule would not have been killed. But if Mr. Malapane had not accepted the contract on Miss Pule's life, the facts of this case strongly suggest that Mr. Shoba would have carried on looking for a way to kill Miss Pule with or without Mr. Malapane's help. Accordingly, the need for parity in sentencing does not apply in this case. While Mr. Shoba and Mr. Malapane killed Miss Pule, their roles in perpetrating her murder and their conduct after it was carried out were quite different. Mr. Shoba was the driving force behind the scheme and has done nothing since Miss Pule's murder to merit the kind of leniency that Mr. Malapani received. Mr. Makabela did not identify any other factor that would justify a departure from the statutory penalty. He drew my attention to the year or so that Mr. Shoba has spent in pre-trial incarceration, but accepted that this could not on its own justify a departure from that penalty. Mr. Shoba, can you stand up, please? For all these reasons, Mr. Shoba, I am enjoined by the statute to apply the ordinary sentence for an offence of this nature. You will spend the rest of your natural life in prison unless the parole authorities consider you fit for release in the fullness of time. Accordingly, on count 1 of the indictment, I sentence you to life imprisonment. You may sit down. Thank you. Is there anything further, Mr. Mohammed?
Nothing from the state side, and that concludes our rule.
Yes, thank you. Thank you very much. The court will adjourn.
All right.
Bueno.